We are officially cleared to release this episode. As usual, just barely cleared, but we're cleared. Which is fitting because today we're talking about something most people use every day in government contracting, but almost no one can actually explain. Those are public laws. Yeah, those things buried behind the FAR and the DFARs and half the clauses you've been flowing down your entire career. Welcome to the GovCon show.
This broadcast has been cleared for public release, but just barely.
Broadcasting from deep inside the federal acquisition labyrinth, this is the GovCon show. This show is for acquisition pros, wannabe pros, and procurement insiders who need a place to unpack the chaos. We speak fluent contracting and sarcasm. No clearance required. This is the GovCon show. And away we go!
Welcome to the GovCon show, where we take the stuff everybody thinks they understand and apply just enough pressure to see if it holds up. I'm Tim Magnuson, and today I'm calling a bluff. Because if I walked into most contracting departments and asked, what public law is this clause implementing? I'd get one of three responses. Silence, a look of confusion, or someone would confidently explain the FAR to me. Which is not the question. And that's the problem, because every day you're not just following regulations, you're executing federal law. You just don't think about it that way. Let me simplify this. A public law is a law passed by Congress and signed by the president. That's it. That's the source. Everything else is downstream. Let me make this painfully clear. Public law equals the requirement. Regulations, being the FAR and DFARs, they're the instructions. If the public law is the what, the FAR is the how, and most people only know the how. I feel all the eye rolls. I get it. Several of you guys are asking, why does this matter? Well, it matters. It matters because you don't understand the law behind the clause. And if you don't understand the intent, you don't recognize the risk, and you don't challenge bad decisions. You're just processing paperwork. Tell you what, let's do this. Let's pressure test it. Here's a question for you, and I'm certain all of you have seen this clause. Truthful cost or pricing data. Let me ask you, what law is that based on? Most people say it comes from FAR Part 15. No, that's the implementation. The real answer is that it comes from what used to be called the Truth in Negotiations Act, or TINA, and you'll still hear a lot of us old-timers refer to it as TINA, which is codified in federal statute. So my point is, if you don't know the law, you don't actually know the rule. And the easiest way to see that is to look at some of the laws that you're already working with every single day, whether you realize it or not. So let's run down a list of those public laws that we all come face to face with every day. First up is one that every purchasing agent, buyer, and subcontract administrator wrestles with every single day, and that is Competition and Contracting Act. CICA, we call it. Now, that's a big one, and this is the reason. Competition is required. Sole source is the exception. Every J&A, every SSJ traces back to this law. Competition is not a best practice. Competition is the legal requirement. Then there's the cost accounting standards, or CAS we call it. People treat CAS like a technical accounting issue. It's not. It's a statutory requirement for consistency in cost accounting. Next on the list is the Berry Amendment. Now, the Berry Amendment restricts sourcing of certain items to only domestic sources. People treat it like it's a sourcing preference. It's not. It's a restriction backed by law. Then there's the Buy American Act versus the Trade Agreements Act. This is where a lot of people really get confused. Buy American equals preference. Trade agreements is override in certain conditions. And most people mix them up constantly. Of course, we cannot overlook the Federal Funding Accountability and Transparency Act. FFATA, we call it. FFATA is why reporting exists. Not because someone wanted a database, but because Congress required transparency. And you know we can't run down a list of public laws without talking about SAM, the system that everybody loves to hate. Most people think the System for Award Management, or SAM, is a system requirement. It's not. It's tied to statutory requirements for eligibility and transparency. And of course, we cannot forget about the Anti-Lobbying Act. You all know this one, I'm sure. You signed the cert. But do you really understand what you signing, what you just certified to? A lot of people don't. Next up is the Foreign Corrupt Practices Act. This one reaches far beyond contracting, but it shows up in your world through certifications, compliance requirements, and international work. Also making our list is the ITAR. ITAR is the International Traffic in Arms Regulations. And people treat ITAR like it's a clause. It's not a clause, it's a regulatory requirement system backed by statutory authority. And when it flows down, it is not optional. Next up is conflict minerals. People see the clause, don't think about the law behind it. But it exists because Congress required supply chain transparency. And of course, we can't overlook the world of counterfeit parts. This is just not good practice. It's a statutory-driven requirement tied to our national security. And then up next, of course, is the small business subcontracting plans. Again, not a suggestion. These are statutory requirements. And here's one that must be on the same page with all of our signatures. DPAS, the Defense Priorities and Allocation System. If you've ever seen a rated order, you're operating under the federal law authority, not a contract clause. Another public law we deal with daily is Public Law 99-500, which is undefinitized contract actions. Most people don't know it by that name, but they deal with UCAs all the time. That authority didn't come from the FAR, it came from the law. Now, I want to slow this down because this is where it gets real. We just ran through a whole list of laws that show up in our world every single day. But I think it's best if we go back through these because this is where the light bulb really goes on, right? Not just what they are, but what they actually do to us operationally. So let's start with Competition and Contracting Act. This is a big one. Let's start with the big one, SECA. It's not just a competition rule. This is the reason competition exists in all federal procurements. Let's talk about what it actually does. It says the government shall obtain full and open competition unless there's a valid reason not to do. That's not guidance. That's the law. And what does that mean for you? Well, every time you see a sole source justification or a limited competition or brand name justification, you're not just writing documentation for your file. You are defending a deviation from the federal law. You want the GovCon truth? That SSJ you're reviewing? That's not paperwork. That's a legal argument. Up next, truthful cost of pricing data. TINA. This one gets misunderstood constantly. People think it's just a certification. No. What it actually is, it's a legal requirement that says if you're not competing, you must disclose accurate, complete, and current cost data, which means you are legally certifying you didn't hide anything, you didn't mislead anyone, and you didn't omit any relevant data. You know, what's the government contracting reality? That's why defective pricing cases exist. Because if you get it wrong, it's not a mistake, it's a violation. Now let's talk about the Cost Accounting Standards Act. Cost accounting standards is where people's eyes just glaze over, especially contracting people. That's a big mistake. Because do you really know what CAS actually does? It enforces consistency in how you account for cost. Not suggestions, consistency. And who cares? Why does that matter? Well, it matters because without CAS, contractors could shift cost around. They could reclassify expenses, manipulate pricing. And what's the GovCon reality? CAS isn't about accounting. It's about preventing games being played. You've also must understand that CAS coverage is contract-based, not contractor-based. So contractors are not CAS covered, but their contracts are. Now, let's go back to the Berry Amendment. People think this is just Buy America-ish, right? It's much stricter. No, it's not Buy American-ish. It's much stricter. Let's talk about what he does. Well, the Berry Amendment restricts certain items to domestic sources only. Not preferred, but required. What does that mean for you? It means if the Berry Amendment applies, you don't get to choose a foreign supplier. And the reality is, that is where supply chain decisions become legal decisions. Now let's look at the Buy American Act and the Trade Agreements Act. This is where even experienced people get tripped up. The Buy American Act sets a preference for domestic products, but it allows exceptions. The Trade Agreements Act overrides the Buy American Act under certain threshold, and it allows for foreign countries. What does all that mean? Well, depending on the procurement, the rules completely change. If you don't know which one applies, you can't evaluate compliance correctly. So now let's move on to FFADA. This is why reporting exists, not because someone wanted more paperwork. What does FFADA actually really do? It requires visibility into where the money is going and who is receiving it. What does that mean for you? That means the reporting requirement you hate, that's Congress saying to you, show us where the money went. Now let's take a look at SAM, the System for Award Management. People think SAM is just a registration system. It's not. Okay, so what is it? What does the law do? The law enforces eligibility, responsibility, and exclusions. And what that means for us, everyday contracting people, if a contractor is not properly registered, they're not eligible for award. So the GovCon reality is that SAM is not administrative, it's our gatekeeper. Next on our list is Anti-Lobbying Act. Everyone signs the cert. Few understand it. What it does? The Anti-Lobbying Act prohibits use of federal funds for lobbying activities. What does that mean for you? How does that affect your job? Well, when you certify, what you're saying is you did not use federal money to influence this award. And the GovCon reality is that cert is not just another checkbox. You're making a legal statement. Okay, moving on to the Foreign Corrupt Practices Act. This one lives outside of procurement, but it hits hard when it shows up. What does it do? It prohibits bribery of foreign officials. What does that mean for you? Well, if you're operating internationally, your business practices are under legal scrutiny. And the GovCon reality is that's where compliance becomes ethics and law. Our next one is my personal favorite, the ITAR, Export Controls, International Traffic in Arms Regulations. And what does the export control laws do? It controls export of defense-related items and data. What does that mean for you? You don't just control products, you control information. And the GovCon reality is sending the wrong file to the wrong person. That is not an email mistake. Up next is conflict minerals. What does it do? Conflict minerals requires disclosure of sourcing for certain minerals. And what that means is your supply chain is now part of compliance. And the GovCon reality is you are responsible for where your materials come from. Next on the list is counterfeit parts. What it does. It requires detection and prevention systems, right? And what that means is you can't just trust your suppliers. The GovCon reality is if the counterfeit parts enters your system, you own the failure. Now let's look at DPAS, or rated orders. What does it do? It gives priority to certain government contracts, which means you may be required to prioritize your work, or you may have to reallocate resources. And the reality of that is the contract might legally outrank all your other customers. Moving on up our list, up next is the small business subcontracting plans. This one requires structured use of small businesses. And what that means is it's not about reporting, it's about documented procurement decisions. And the GovCon reality? If it's not in the file, it didn't happen. Now let's look at Public Law 99-500, UCA's undefinitized contract actions. And what it does? It controls the use and the timing of all undefinitized contracting actions. What that means? It means you cannot operate indefinitely without definitization. GovCon reality, that handshake agreement, it has a clock on it. Now, step back and look at this. All of these clauses, certs, requirements, they don't start in the FAR. They start in law. The FAR didn't invent these rules. It translated them for us. So let's pause for a second because this is the moment where people realize I've been doing this for years and never thought about it this way. Well, you're not just writing contracts, reviewing clauses, and managing compliance. You're actually executing federal law through contracting actions. And that sounds big. It sounds important. It sounds a little abstract. So let's translate that into what it actually looks like on a Tuesday morning, right? When the emails are piling up and the program team wants speed and nobody is saying the word law. but it's driving every decision you make because this is where things start to break. Like this problem, blind compliance. When people don't understand the law, they follow rules without understanding why. Second problem with it is bad decisions. They accept things like bad sole source justifications, irrelevant flow downs, and misapplied clauses because they don't understand the intent. And then third, audit exposure. When auditors show up, Defense Contract Management Agency Government Accountability Office, they're not just evaluating compliance, they're evaluating alignment with the statutory requirements. By this point, you're probably asking yourself, well, heck, what does doing a good contracting job or being a good contracting person actually look like? Well, a strong contracting professional understands the regulation, but also understands the law behind the reg, because that they understand that's how you make better decisions, challenge bad requirements, and explain risks more clearly. When you understand the law, you stop being a processor and start being an advisor. Let me leave you with this. You're not just following the FAR. You're not just managing contracts. You're implementing federal law, whether you realize it or not. And the sooner you understand that, the better you'll get at this job. Okay, if this episode made you rethink how you look at your clauses, great. That's the point. Next time you see a requirement, don't just ask, what does the FAR say? Ask, what law is this coming from? Because that's where the real answer lives. If you've got something out of this episode, subscribe, share, and send it to someone who could use a good dose of contracting reality. And if you want more like this, head on over to thegovconshow.com. And don't forget, this episode of the GovCon Show has been cleared for public release. But just barely.
If today's episode sounded a little too familiar, that's probably a sign. Until next time, keep your files tight, your logic tighter. Remember, if your compliance approach is built on checking boxes, you're building risk. We'll see you next time on the GovCon Show.
This broadcast has been cleared for public release, but just barely.